Welcome to Know Your Rights, New Jersey. I am your host, Rhinold Ponder. On today's show, we discuss the status of affordable housing law in New Jersey after the state Supreme Court rejected Governor Christie's effort to dismantle the Council on Affordable Housing. We are pleased to have Staci Berger, President and CEO of the Housing and Community Development Network of New Jersey. Welcome, Staci.
Thanks for having me.
Thank you for joining us. Let's start with the state or the status of affordable housing in New Jersey. Tell us about where we are now.
So New Jersey consistently ranks as one of the least affordable places to either rent or own a home. We're at the top of the foreclosure crisis. We flip back and forth between Florida and Nevada, but we're always in the top three. We do not have enough places for people who want to stay here and raise their family or retire here. And so it's really an economic and social issue. It's not just the individual people who maybe can't afford to stay here, but it affects our entire community and our business climate. If people who are starting businesses or looking to relocate their business or expand their business here feel they can't hire employees who are going to stay here, who are well trained and can afford to live in New Jersey, they're not going to expand their business opportunities.
So what work do you do to ameliorate, to try to resolve that?
Sure. So the Housing and Community Development Network is the statewide association of nonprofit community developers and financial partners who want to see our communities thrive and be vibrant for everybody. We really believe that a strong New Jersey is going to happen when we have strong communities all across the state and that people have choices about where they want to live and work. So we work to make sure that the policy at the state level and the federal level really encourages community development, both from the private and the public sector.
So those of us who know very little about affordable housing, we always hear Mount Laurel this, Mount Laurel that. Can you give us a synopsis of what does that mean to affordable housing here in New Jersey?
Affordable housing, it really our constitutional requirement that communities provide a realistic opportunity and that they not use their zoning laws to be exclusionary came out of a series of court decisions that were started by folks in Mount Laurel who were denied the opportunity to build affordable homes in that area. The mayor famously said, if you can't afford to live here, you have to move. And our Supreme Court said, not so fast. You need to be able to provide an opportunity for people to build the kinds of homes that they can afford. So that's been 40 years of legal precedent in New Jersey. And there's been a lot of back and forth between the courts and the executive branch, regardless of the governor, and the legislature about how to really implement that and make it real for people.
Okay, so you're saying that we actually have a constitutional right to affordable housing in this state?
We have the constitutional requirement that communities provide a realistic opportunity for people to build them. That's not the same thing as saying, I get to have this house in this neighborhood. But a developer who wants to build affordable homes for people who want to live there can't be turned away through the use of exclusionary zoning ordinances by a local community.
Okay, so if this is the state of affordable housing, my understanding is that the Christie administration is somehow trying to change the rules, or has tried to change the rules. How is that?
Well, the governor ran, when he first ran for governor in 2008 and succeeded in 2009, he ran on a platform that included language that was very inflammatory about the Council on Affordable Housing. He promised in a number of campaign events that he was going to gut the Council on Affordable Housing, which is the regulatory agency that the governor's office oversees that determines how many homes a community would have to build in order to meet that realistic obligation.
So how does the Council on Affordable Housing make those type of determinations? Do municipalities go to the council? Do developers go to the council? Or do set rules? What do they do?
The council, or COA as it's commonly referred to, has a methodology that was approved by its own board and had been upheld by the Supreme Court for almost 20 years, where they evaluated how many homes were needed in the region, not just within that town itself, but what was the regional need for those communities, and what was the available land, and what were the economics. And so there was a formula by which every community said, if we want to participate in this system, and it's a voluntary system, if we want to participate in this and not risk being sued because we didn't meet that standard, If we want to take our chances in the courts, you can do that. But if you want to say, we don't really feel like being sued, we're going to do this, we're going to go through this methodology instead, they had a number that they agreed to and they had to meet. And in the third round is really where the wheels came off for the council.
What do you mean by in the third
Well,
round?
they tried to change the rules very drastically, and there was a lot of opposition to them, and the governor ran on a platform of not just making rules that everybody could live with, but just eliminating the agency entirely. And that turned out to not be doable under an executive order, which the governor did try to do, and which a number of organizations, including ours, opposed, and the Supreme Court did not let him do that. So the council still existed, but it didn't have rules to operate under.
And so the council existed, but I guess what you're telling us is that it had no power, or it was not exercising the power that it was supposed to exercise.
The governor was really trying to reduce its ability to exercise its authority. So he was trying to make good on his promise to gut it. And while he couldn't completely eliminate it, he did make it very difficult for the council to operate, and proposed through the administrative procedures that are available to him a series of rules that were just not feasible under the law.
Were those rules agreed to by COA, or was COA in a position to?
COA had to adopt those rules, and they chose not to. They were not able to come to a majority vote on those rules, and that's because of significant public pressure against them. There are a number of parts of those rules that would have significantly reduced the number of homes that would have been affordable to lower and moderate income families in our state.
So, what would have been, assuming that Governor Christie's plan would have succeeded, what would have been the end result of that? How would that have harmed?
What would have happened is communities could have done whatever they wanted and maybe created some affordable homes, or maybe not. But that would not have been in compliance with the 40 years of case law we have under the Mount Laurel decisions that we discussed earlier. So we have a tradition, a very strong tradition and historic legal precedent for making sure that communities meet the obligations within their borders for their area to provide a realistic opportunity for people to live there.
So tell us a little bit about how the public pressure and the work that you've done, what exactly happened to change to make it more difficult for that to be this dismantling to be successful?
So we do a number of things when we engage in a public policy campaign. We encourage our members, of which there are more than 150 community organizations, including right here in Princeton Community Housing, to write letters to the member of the COA board, come and testify at the COA hearings, write letters to the editor, submit opinion editorials, and talk to their local and elected officials about the importance of affordable homes in their community. Princeton, we actually gave Princeton an award for doing such a great job. Yeah, I mean, Princeton really has made huge strides in providing affordable homes within its municipal borders, using its own municipal housing trust funds and working really creatively with organizations, nonprofits like the Princeton Community Housing.
Now, what is it that individuals who'd like to be more involved in the process, or involved in your organization, or attending COA meetings, for example, as you mentioned, how would they go about becoming involved in this?
Well, they can always join our organization. We are always happy to have more individual members. They can stay abreast of the news, really following what's happening in the local newspaper, and I know the media around here does a great job. They can get involved with Princeton Community Housing or any of the other nonprofits that are in the area. Homefront, which is just over the border in Lawrenceville, does great work providing transitional and homelessness solutions for families, particularly women and children who are in need of rehousing and permanent safe housing. So there are lots of volunteer opportunities, and then there are advocacy opportunities. And one thing I always like to tell people is if they're in trouble themselves, call your elected official. Folks who work day in and day out serving the public have access to information that can be very, very helpful. And also, it helps those elected officials know that there's a problem in their neighborhood or in their backyard. And they can't really take a good policy position or be proactive on those issues if they're not aware that they're happening. So, really get to know your state and local elected officials.
Thank you, Staci. We're going to take this opportunity to take a short break.
Okay.
And we will be back to discuss with Staci the Supreme Court decision, which has caused all the brouhaha about the future of affordable housing. We'll be back in 30. Welcome back to Know Your Rights, New Jersey. We are here with Staci Berger discussing Mount Laurel, affordable housing, and now I wanted to talk to you a little bit about the recent Supreme Court decision which defeated Christie's plan. Can you tell us a little bit about that?
Sure. There were a series of court cases that led up to the final decision a few months ago. It feels like yesterday, but a little while ago, where the court, by a 6-0 unanimous ruling, including members of the Supreme Court that the governor himself had appointed, found that the governor's proposal for third-round rules under the Council on Affordable Housing were null and void. And they really found not just that the rules didn't do what we needed to do, but that the agency itself was moribund, to use their term, and was not really capable of...
Moribund?
Yeah.
Dead?
Not quite dead, but really not doing so hot. Not capable of carrying out its responsibilities to the state of New Jersey and our taxpayers and residents here. And so the Supreme Court did something that they haven't done in a long time. They took control back of the housing planning process for municipalities. Previous to the Fair Housing Act in 1985, the courts were really the main avenue for communities and developers to determine what the appropriate number of homes would be in an area. And the legislature said, we really want to give communities the opportunity to not have to go to court.
And that's why COA was developed?
And that's why COA was developed, and there was a whole set of methodologies that we discussed earlier about what the number that communities had to meet were.
So now, since COA is now considered moribund by the Supreme Court, what did the Supreme Court do to resolve that problem, to create an avenue for people?
Sure. So the court has basically said, we're going to take that back. You had a shot at it at executive branch, and it didn't work out. So for now, we're going to take that back, and we're going to assign, I think it's 15 trial judges to cover 21 counties, and in those courts, municipalities will have to say, yes, we want to participate in this process, or no, we don't, similar to COA. Then they are going to have to submit a plan, and that plan is going to have to include the realistic opportunity for the creation of homes people can afford in those areas, and they have to be based on the second round rules. So we're going to go back to rules that we know worked. They weren't perfect necessarily, and yes, New Jersey has changed since then, but more or less the second round rules were something everybody could live with. And so we're going to look at what the numbers were for those communities in that time period, and we're going to add in the fact that nobody's been held accountable really for the last 15 years because we didn't have rules. So those numbers are going to be much bigger, but they're going to go forward through another 15 years, so 2025, 10 years, 2025, and we're going to say to communities, okay, you come into the court, and the court says, yes, your plan meets these needs and objectives, and you have sign-off from the advocates. Fair Share Housing Center, which is one of our colleague organizations with whom we work closely, was the lead in the lawsuit, and the courts actually said that Fair Share has to look at all of the plans, and then nonprofit developers can have an opportunity to weigh in and work with those municipalities. So we're really excited about the opportunity for nonprofit organizations, legal advocates, and municipalities to put a plan together and go before a judge and say, we all agree this can work, and then the judge can say, great, go do your thing.
But does the state have an opportunity to regain its authority?
The legislature could act, but we don't really see a need for that right now. We would like to see this process play out, and if there are challenges or obstacles, we can address them down the road.
So you consider this or do you consider this a great victory for affordable housing advocates?
We do, because we've waited a really long time, and lots of people who need homes aren't getting them. And to go back and try to get this governor and this administration to make COA work just doesn't seem like that's going to happen. And people can't wait to have an affordable home. They've been waiting a really long time, and a lot of them have chose to leave New Jersey, and that's bad for our state. It's bad for our communities, and it's bad for our business economy.
So now, what will your organization and what will advocates do from here on to take advantage of this ruling?
We're going to be working with every municipality that wants to work with nonprofits, help them get in touch with the local nonprofit if they're not already doing that. We'll help them coordinate, and we'll help provide training and technical assistance to our members who actually put hammers and nails to wood and build those homes, and help them get the resources that they need to make sure that those homes get built.
Now, is there a specific impact of all of this on Hurricane Sandy victims?
There's a real opportunity for Hurricane Sandy victims. Part of what happened in this whole delay was that there was money set aside in communities around the state to help build those homes. But because there weren't rules, many of those communities didn't spend the money. The governor tried to take that money. And and about $80 million of those funds were in communities that had been very heavily hit by Superstorm Sandy. So as a result of this ruling and a more recent ruling by the Supreme Court that allowed those trust fund dollars to be used in accordance with the new rules under the Supreme Court, many folks who've been impacted by Superstorm Sandy will now have a better opportunity to have a new home built or a home reconstructed in their area. So instead of taking that money, which we fought very hard to prevent the governor from doing in 2011 and 2012, those funds remain with those municipalities, and now they can use those funds to help restore the communities that were hurt by Superstorm Sandy. So we're really pleased by that. The other piece that's interesting about this decision was one of the things that changed between the second round and the third round were something called regional contribution agreements, where
and what you when you refer to second round, third round, because I was also going to get back to those are the rules. So what changed from the second round rules, which we're going back to because of the court, and the third round,
which were never really in place. They were sort of theoretical proposals, really. In 2008, then Governor Corzine signed legislation that prevented communities from transferring a portion of their obligation to another area. So communities in Mercer County, who didn't want to build the entire number of units that they needed to, number of homes that they needed to, could actually pay another community to take on that responsibility. And that didn't really get the homes built that we needed in either area. And so that rule is no longer available to those communities. So what's a little bit different now is that the communities that have an obligation have to build all of those homes within their borders. And so that's going to be challenging, but we absolutely think that it's doable.
Okay, and I don't want to get too bogged down in details
Sure.
That aren't necessary, but you mentioned that the second round rules will go back to them, but they aren't quite adequate. How do we get to change those rules? So what did the court provide for how those rules would be more appropriate for today, how to change those?
So what they really looked at was the methodology and not the end result. And the methodology is fairly, seems to be across the board agreed upon as usable. So what the court is going to do is the advocates are going to come in and say this community X needs to do, I'm just picking a number, 300 homes. And the community may say, well, our community has changed a little. We really think we only have to do 200. And the court may say 300 here, 200 here, 250, and everybody can live with that. I mean, that's how we expect there'll be some negotiation back and forth. There may be, places that have added quite a few businesses, and maybe they need to do more than they thought they were going to have to do. Or maybe they've preserved farmland or open space since the last time, and they need to do something different. And that's one of the reasons those rules were so really not helpful, was because it prevented communities in some places who had developed innovative ways to provide affordable homes without necessarily constructing new ones, but taking existing homes and making them affordable for families who wanted to live there. East Brunswick, for example, has a great buy-down program where they use that local funding to actually purchase a home, sometimes a foreclosed home, and this is something that Princeton Community Housing did as well, to purchase those foreclosed homes, make them permanently affordable for families who need that, and keep them affordable for a really long time. And that would not have been permitted under those rules, which seems sort of crazy.
So what do you see as some of the next battles in affordable housing for New Jerseyans?
I think really recovering from Superstorm Sandy and making sure that we have enough affordable rental homes. We're going to be releasing data in a week or so about the state of New Jersey in comparison to other places around the country. And while I can't tell you now how we rank, I can tell you in the last 4 or 5 years, New Jersey has been consistently at the top, if not the number 2 or 3 slot, certainly in the top 5 of least affordable places for families who rent to afford to live. We actually surpassed New York State last year, and while some of New York State is very affordable.
I'm trying to be objective, but I'll say wow.
Yeah, it really was. I was pretty stunned that we surpassed New York, because even if you took out places that are more rural and have a lower income in general, which might make them more affordable, more rural upstate parts of New York State, you still have Manhattan to include. And so the fact that we're more expensive than than that, which was the first time that it happened, was really very depressing. There were some statistics that came out of that report where we found that in order to afford a fair market 2-bedroom apartment, somebody in New Jersey would have to work 3 full-time jobs at the minimum wage. Now, if you could find 3 full-time jobs at the minimum wage in New Jersey, that would be one thing. But you can't find those jobs, and really that's just not how a civil society ought to treat people. And so we really need to create more homes that people can afford so that we do better by our folks.
So let's take a moment and finish up with foreclosures. What,
Sure.
what do you see happening there?
Well, I think we continue to be at the top of every study about the number of foreclosures that New Jersey has relative to other states. We don't really have a strong foreclosure policy at the state level. We do not have a really robust opportunity for people to negotiate a better mortgage with their lender and try to stay in their home. And so what we really need is a strong public policy initiative from the front office, from the governor and the legislature. The legislature has adopted a number of opportunities that the governor has vetoed. And really foreclosures hurt the family that's being foreclosed on, they're bad for the bank, and they're bad for the neighborhood. And so we really need a way for our state to say, we know this is a problem, this is a crisis, and we're going to put some resources and some energy into solving it.
Staci, thank you very much. This has been another informative pleasure.
I'm happy to be here. Thanks for having me.
And thank you for joining us for another episode of Know Your Rights, New Jersey. Until next time.
Thank you.
Thank you.